Okay.
And I'm starting the broadcast.
All right. Good morning, everyone. This is Jenny Pakula, CEO at the Oregon Realtors. And today we are going to hear from Professor Kelly Murray from Vanderbilt Law School. And if you don't know what a clue report is, you should. And if you haven't ever utilized clue reports, I don't think you will engage in another transaction without doing so after you listen to Professor Murray. Excuse me while I put on my glasses to properly introduce Professor Murray to you. Professor Murray graduated Phi Beta Kappa from Stanford and cum laude from Harvard Law School, so she's not very bright. She is the lead faculty investigator for the National Family Court Project on Housing and Financial Justice and on the faculty at Vanderbilt Law School since 2005. As a speaker and interdisciplinary continuing education trainer, Professor Murray co-founded DivorceThisHouse.com in 2008 with Wendy Wassell, I don't know if I pronounced that correctly, and has taught divorce real estate to over 2,000 judges, lawyers, mediators, and collaborative professionals in 16 states, as well as hundreds of mortgage and real estate professionals. For those of you who attended the NAR convention in San Francisco last fall, you might have had the pleasure of seeing Professor Murray present this class. It was with great demand that I was asked to look into bringing this course to Oregon. And having some familiarity with clue reports, I do understand the importance for you all to be aware of what they are and how to use them in your practice. So without further ado, we'll turn this over to Professor Murray and submit your questions via chat, and we'll get to as many as we can. Take it away, Professor Murray.
Thank you so much. Now I have a worksheet that I will be primarily focused on showing you what to fill in the blanks and where, because we know that writing is how our brains learn. I give the data to my law students, my first year law students, every fall semester. Typing is just a pass through. Writing actually helps you learn and retain the content. And so today we have content, we have interesting information, and we have practical takeaways. And we've combined those two. If you look at page 2 of the worksheet, we have 3 takeaways. And so the first is to confirm the essential role of the clue report. There is an essential role for it to play. It should be more utilized than it has been. And we're going to look at why. Second, we're going to show you how to help your buyers get the clue report indirectly. So go ahead and even write on that worksheet. Buyers, it's only indirect access. The only participant in a residential real estate transaction who has direct access would be the seller. So the seller has direct access, but the buyer needs it. And we're going to be looking into that as well. And then finally, we have a simple script. Now, most of my scripts and most of my trainings are simple. Less is more, particularly when I'm teaching real estate agents how to work with lawyers. And in my case, how to work with divorce lawyers. So we have a single sentence for you to add to a Zoom or telephone conference with a for sale by owner or prospective listing that can help you get that listing presentation and then land that listing. So those are our 3 takeaways. This is page 2 of the worksheet. Page 3 gives you an introduction to Wendy Wassell and me, your faculty. And then page 4 is our table of contents. And we have 5 segments. The clue quiz is where we'll start. What is clue? What does it stand for? Some of the important data about clue. And second, the clue data points. There are 2 key federal statutes we need to keep in mind. Third is the clue statistics and 2 important surveys. We have 2 national surveys, 2014 and 2016, that updated the data nationally about clue and homeowners and their understanding, or in our case, misunderstanding about clue. And then gaps, clue gaps in residential real estate, wrapping up with that final clue question. So if you want to know what that question is, stay tuned, because that's at the end of today's presentation, not at the beginning. So if you're writing in the chat, what's the question? We're not going to answer it until the end. But now I'm on page 5, and at the top of page 5 is our clue quiz. And we need to know these things because you can't incorporate clue into your residential real estate practice if you don't know what it stands for. So we need to write it down. Ready? Clue stands for comprehensive loss, underwriting, exchange. So clue stands for comprehensive loss, underwriting exchange. If you bring up Clue and they say, well, what does it stand for? You need to know the answer. So that's the answer. Now, Clue covers houses and what else? There are two other data sources for Clue reports. Clue covers houses, and it also covers people and cars. We're going to be talking about people and houses, not cars. But there is a Clue report for cars because people have cars with insurance. If you file a claim, there's an insurance claims history that follows your car and you. So Clue covers houses, people, and cars. We're focusing on the houses and the people in this session. And then number 3, how many years do we need to be concerned about Clue? And I want you to write 3 numbers, 7-5-3. Go ahead and write 7-5-3. 7, the Clue report retained officially goes back 7 years. An insurance underwriter can see 7 years of Clue history. 5, I want you to circle 5. 5 is a big deal. 5 is the number of years that the Clue report, the home seller's disclosure report, only goes back 5 years. So a seller who contacts Clue to get a report that takes out their personally identifiable information so it can't be used to steal their identity, that only goes back 5 years. Another piece of Oregon is you have a statute, and the Oregon statute is section 746.686. So that's ORS, Oregon Revised Statute 746-.686. And in Oregon, whether you're applying for insurance, property and casualty, or renewing property and casualty, they cannot look at a claim more than 5 years from the date of your application. That's according to your statute. So that makes 5 an important number. It's already an important number, but it's a very important number in Oregon. And then 3, this has come up anecdotally. And what I mean by that is I am a lawyer and I always look for citations, and I don't have a citation for what I'm about to tell you. But I've been hearing this from insurance professionals that sometimes they only underwrite by looking at the previous 3 years. So 3 is an important year segment because if you have a lot of claims within 3 years, that's the worst. A lot of claims close together within the previous 3 years is the most dangerous prospect for this house to be in. So 3 still matters. And then in Oregon, of course, they can underwrite, they can look not past 5 years of insurance claims, but up to 5 years. Number 4, I already gave you this answer in the intro, so let's test our knowledge. Number 4, who has direct access to the Clue report? Only the seller. Only the seller. We used to be able to access Clue, and I'm talking over 10 years ago when I first started teaching real estate continuing education, from the companies that gave us those natural hazard reports. You used to be able to buy a Clue report on top of it. No longer, because Clue is a credit reporting agency. This is protected by those same federal statutes. So only the named insured seller can access the Clue report. Doesn't mean the buyer shouldn't be asking for it, and that's why this buyer needs you as their realtor. But only the seller has direct access, which affects our strategies. Number 5, what percentage of insurance underwriters, insurance companies, brands subscribe to Clue? It's 90%. There are actually 2 competitors. Clue has a smaller competitor. We have 3 credit bureaus for your credit score. We have 2 insurance claims history companies. Clue is the big player. It's almost the Kleenex of the category. We don't really call it insurance claims history. We call it Clue. But that's Clue, and the competitor is called A+. So Clue has 90% market share, which means it's mainly one-stop shopping. You wouldn't see different results in each insurance claims history database. And then number 6, so what do you think about this? Does pulling a Clue report affect your credit score? Is it a hard hit, a soft hit, or a no hit? So I'll pause so you can write down what you think it is. Pulling a Clue report, is that a hard hit, a soft hit, or a no hit on your credit score? Answer is no hit. It's a no hit. So if that sounds confusing, because I just told you that the credit reporting statutes federally affect Clue and your credit score, but pulling a Clue on your house or for yourself personally is a no hit on your actual credit score. So that's good news. There is no hit. And then one thing to keep in mind, any insured, any named insured of a house can get one free clue report per year. So this is going to turn out to be an important piece of information that we have free access to. And even if you've already used up your one free clue report per year, it's under $20. So it's not an expensive report, which is why we're going to talk about its value, the value it brings, and these strategies for using Clue, leveraging it as a listing presentation, as part of your listing presentation tools. Now, at the bottom of page 5, I have 2 case studies to talk about. The first came from the Washington, D.C. area. This was actually a buyer's agent. So a realtor wrote this article. It was in the Washington Post in 2015. She was the buyer's agent. And let's just go through some of the data here. She represented the buyer. They already had the home inspected. And then when they were underwriting insurance, because as a buyer, you cannot get a mortgage if you don't have insurance and keep insurance. So if you lose your house insurance, you can lose your mortgage, or what really happens is you get put into forced placed insurance. You get that mean letter from the loan servicer saying, we're going to buy house insurance for you and it's going to cost a lot more and cover a lot less. So nobody wants to be in forced placed insurance. Costs a lot more, coverage is not favorable for the homeowner. All right. So they were underwriting her buyers. They smartly went to the insurance agency, were getting underwritten for house insurance needed to get the loan on this house. And the insurance agency did not give the buyer the clue report, told the buyer, and this is something we need to interview our insurance folks about, told the buyer about a clue listing, told the buyer about a $9,000 claim that was paid by the insurance company to the sellers for tree damage to the roof, $9,000, and this had not been disclosed. The $9,000 had not been disclosed because apparently it had been remediated fully, that they had removed the tree and repaired the roof. But as the buyer's agent and the buyer's home inspector, how would this change the actual physical inspection? Well, here's what they did. They brought in a roofer to make sure that the roof had been properly remediated. They brought in a tree expert to find out, are there any other trees in proximity to this house that may be older or rotting or have some tree disease that caused it to fall, or in a strong windstorm would cause it to fall. So notice how it changed the inspection process. This information changed the inspection process, and the damage was not disclosed because it had been repaired. Something else I want to tell you, I have a lot of sidebars. I'll try and limit them to our 50 minutes, but one of the sidebar is, if insurance claim is paid and the repair is either not made or it's not repaired properly, any further damage from the unrepaired or improperly repaired roof, for example, is not covered by your insurance, and you can lose your insurance. So this is serious. If an insurance company is paying the money, that repair needs to be made and it needs to be remediated effectively. Now, the second example, as a lawyer, I've been teaching residential real estate issues in family disputes for over 10 years now. And so I update my research, what other lawyers are writing about clue reports, and I've only found this one article. So the only other lawyer I've seen writing about clue is a Wisconsin real estate lawyer, and he was writing about residential real estate, not family disputes and divorce real estate that I focus on. And this article is from 2004, and it was called Clue Reports, a tool to discover property problems. Now that's the reason we all should be thinking about this. That is absolutely the reason we should all be thinking about this. What property problems and what role they play in residential real estate. They affect your negotiation, they affect the offer, they accept the counteroffer from the seller. So he was writing, what if a hypothetical house was struck by lightning? Did it simply short out the flat screen TV, or did it compromise the wiring in the whole house? Your home inspector would inspect differently if he knew the house had been struck by lightning. Now, there may not be scorch marks remaining outside of the electrical sockets that may have been repaired, but he would inspect differently. And so was the wiring compromised? Was the harm limited to the flat screen? But assuming that you found out about the lightning strike in the first place. So that hopefully gives you the why. Why should we care about the clue report as the buyer's agent? Those are some reasons why. Now, turning to page 6 of your worksheet, page 6, we have 3 clue keys. And so I've grouped these into 3. Some of them we've already covered, but it's another way to think about the same information. So we've mastered why clue matters for our clients as sellers and as buyers. So first, 3 for 3, the source. The 3 clue sources are houses, people, and cars. Those are the sources of information. So if you are a person who owns a house and you've insured it, and you file a claim on your house, there will be 1 claim on your personal clue report and 1 claim on your house. Your personal clue report follows you, but if you sell the house, that claim that you filed stays for how many years? 7. How many years does it matter in Oregon? 5. How many years does it matter for current underwriting? Probably 3, but we need to check with our insurance folks. So that's how this works. Clue claims follow the house. When a claim is filed on a house, that house has a clue report, and it goes up to 7 years of history. You have a clue report as a named insured, and when you file a claim, that claim stays on your clue report. Well, what if in this same year you would file the claim on the house, but you also filed the claim on your car insurance? Your personal clue report would have 2 claims for this year, 1 for your house and 1 for your car. And the same thing, it follows the car the same way as it follows the house. That's what I want you to think about in terms of those sources. 3 for 3, the duration, right? Again, 7-5-3. What's 7? That's how many years clue collects data on a house. Year 8, it drops off. So if your big insurance claim was 8 or 9 years ago, it is dropped off the clue report. 5, that's the number of years in Oregon that you can be underwritten, up to 5 years of a clue claim. And then 3 years is the number of years we know are the most critical. That's what's looked at most carefully because that predicts risk for the insurance underwriter. Now, 3 for 3, the number of claims. I want you to write 1-2-3. We're doing it in the inverse. 1 claim is not good. Here's some good news about Oregon, though. You get a free pass because under that same statute, so I'll give you the citation again, ORS section 746.686. Under that statute in Oregon, you cannot be underwritten based on 1 claim. It can't affect you. So you get a free pass on 1 claim on your clue report. That is really good news in terms of underwriting. 2 claims though, so I just talked about 1. The other issue with 1 is 1 insurance claim can increase your house insurance premium, just 1. Now 2 claims, what's the deal here? In Oregon, that means the second claim can affect your underwriting, the renewal or even the issuance of insurance in the first place. And it also can increase your premium, 2 claims. And here's the other issue. Between 2 and 3 claims in a 3-year period, you can lose your insurance.
So Dr. Murray, just to clarify, the claims, number of claims, 2 separate beasts, right? You have the clue report and then your insurance carrier bases the premium. I mean, not will you get a free pass on 1, but your premium can be based on the number of claims that are noted. That's how they determine, right? That's how underwriting looks at your clue report to assess what your premium is going to be.
Absolutely. So if, let's say you're buyer, you're the buyer's agent, your buyer is being underwritten for a house. If that house has 2 claims, that house looks risky. It looks like a lemon. And it's all about risk. What the insurance companies are underwriting is the likelihood of you filing another claim. It's the human adjuster that's their biggest cost. Yes, acts of God cause expensive damage, but they regularly underwrite hoping to avoid needing an adjuster. So it's the likelihood, the risk for the insurance company is the likelihood of you filing a claim. Again, are you likely to file a claim on this house? It's had 0 claims in 5 years, looks like, and you have no claims on your clue. Wow, your buyer looks really good. So if your buyer has claims and your house has claims, that's the perfect storm of looking like you're going to file claims.
So they're going to check out the, as you noted, 1, 2, and 3, they're going to check out the people and check your own personal clue history. Plus they're going to check the house and look at those together.
Absolutely. And this is one of the things I've always admired from afar about the Oregon Association of Realtors. Your buyer guide and your seller guide give the most specific warning I have seen in the country.
Oh,
so actually, and I have it as a worksheet, so we're going to get to it, but I've admired it from afar for years because you're the only association that says, hey, this will affect you. So when we get to it, we will admire it again.
Thank you,
It's
Professor.
nice to be able to say I am a fan because I actually have been a fan of that. I'm a research nerd. I'm always looking for reference, and it's an excellent reference. So I want everyone to be looking at that particularly. I know you've used that guide. It's a tremendous thing. You already knew that, but I'm going to show you how to use it in terms of clue.
Excellent.
Then we have two vocabulary acronyms. CWP, closed without payment. CWP stands for closed without payment. That's the worst. You do not want a claim that was closed without payment, because that means you have a ding on your clue report and you receive no money. And how does that happen? That's filing a claim less than your deductible, or filing a claim that you don't have coverage for, like water seepage. So for example, water seepage is usually not covered. And if you file a claim because there's water seepage in your crawl space or your basement, they will close it without payment. The next one is open in error. So OIE stands for open in error. And this is what we need. We need a claim that shouldn't be on your clue report because, so for example, if let's say a house investor owns multiple properties, and on one of his properties, he files a fire claim, but the fire gets noted on a different property that you bought. That would be a fire claim in error. So that can get fixed. And that's the whole point of open in error. Open in error is the intermediate step to get an erroneous clue listing removed from your clue report.
And
Just
who
like
would
something wrong on your credit report.
does the buyer, the respective person have to file that claim, or can your agent do that on, not your real estate agent, but your insurance agent do that on behalf?
The actual insured has to do it.
Okay.
But the good news is it's there, and we're just about to look at the two statutes that give us this ability. And this is a good thing to get things fixed. But that example I gave shows you how it happens. That actually happened in early 2000s to an aide to the insurance commissioner for the state of California. That actually happened to his aide when he was trying to create regulations that the California Supreme Court smacked down as beyond his authority, requiring the legislature to pass statutes and not a regulatory action.
Got it.
So some state insurance commissioners have tried. Oregon, you already have some very good legislation passed. So that's good news. You also have, and just to bring this up, the same statute I've given you shows that an mere inquiry cannot be a clue listing. That would be an error, and that's prohibited by the same Oregon statute. So 2 thumbs up to the Oregon statute, okay? This is some good news. All right, the next part of page 6, we have 2 federal statutes that govern not only your credit report and your credit score, but also your clue report. The first one is the FCRA, and I'll tell you what it stands for. The second one is the FACT, F-A-C-T. So FCRA stands for Fair Credit Reporting Act, and that's the big statute. The FACT Act actually is a subset of the FCRA. You have FCRA and you have the FACT Act. The FCRA gives us the ability to correct errors. It's one of the things it does. It gives us the ability to correct errors, which I was just talking about with that open in error scenario. The FACT Act gives us 1 free clue report per year. It also gives us 1 free credit report per year, and that's annualcreditreports.com. But annualcreditreports.com, mandated by the Federal Trade Commission, the FTC, does not give you your credit score. It gives you your credit report, but not your credit score. Now, why is Clue a mystery? I have 2 surveys to prove. I don't have to ask if any of you are using it, because I know most realtors nationwide are not using Clue. How do I know this? Because America is clueless about Clue, and I have 2 national surveys to prove this, and including the 2016 survey, which updated the 2014 survey, shows America is 3% more clueless than we used to be. It went up from 83 to 86% in 2016. So I have it on the worksheet, and you can just follow along. I'm not having you fill things in, but 86% of respondents in 2016 had never heard of the Clue report. Wait a minute. These are home buyers. They own houses. They've never heard of it, and they own a house. Guess what that means? It means most of them work with a realtor, and most realtors are not using Clue, because realtors are involved in most residential real estate, and the majority of respondents had never heard of it. 5% were somewhat familiar with Clue. Only 5%. America is clueless about Clue. Staying with the 2016 survey, 88% of respondents did not request a copy as a buyer. I have a relative who sent me a signed purchase offer on the house. And I said, why did you send it to me signed? You can't do anything. I can read it, but you can't change it. And so I told this relative of mine, ask the seller to give you the Clue report, even though the offer had already been signed. And the seller said no, because they didn't have to, because it wasn't in the offer that was accepted. So they can say no. The only way to require a Clue to be disclosed is to put it in the offer. Now
So
we'll talk about, go ahead.
I'm sorry, a question that came up that is relevant, and obviously the insurance brokers pull the Clue, but do lenders pull a Clue report?
From now this is me just teaching a lot of lenders. They don't. They can, but they don't. And it's the same surprise I had when I first started on this topic over 10 years ago and realized lenders don't require home inspections. And they don't require home inspections because they think the appraisal predicts loan performance. They're just looking at loan performance. They're really not looking at the quality of the house.
Wow,
They're simply trying to predict loan performance.
Seems like a really easy way to check on your collateral.
Yes, I felt this way for over a decade. To me, I wouldn't be a jumbo loan with no home inspection. Are you kidding? I would not be doing that. So yes, we have that issue. Okay. So then right under the 88%, only 12% received the Clue report before buying their current house. Only 12%. So I don't have to ask. Now I live in Tennessee, but I'm not from Tennessee. But all y'all are not using the Clue report. I know this because of this survey, if only 12% actually received it. So let's look at the 2014 survey. In 2014, 75% of respondents did not know that their house insurance premium could be affected based on the prior owner's claims on this house. 75% had no idea that items on the Clue affect the underwriting of the house you're trying to buy. And then the next one was much more shocking to me. That same 2014 survey, 51% of respondents did not know that their own claim could increase their insurance premium. It's a use it and lose it. Even with good legislation, insurance is somewhat use it and lose it. You're in more danger the more claims you file. We already talked about that. So page 7 at the top, what's wrong with filing one small claim? Well, the first thing is you've used up your freebie in Oregon. You file your first claim, you really don't want a second claim within the next 3 years. You absolutely don't. Ideally, not even within the next 5 years, because we know in Oregon, you can be underwritten based on the number of claims within 5 years, but not your first claim. So you get a freebie. So the first one means you used up your freebie. It can still increase your premium. No, actually it can in Oregon. So that's a line I teach elsewhere, but I don't think that works in Oregon. So one small claim gets you on the path towards more claims. That's what's wrong with it. 2 claims are very not good. And I said it that way on purpose. It's not good to have 2 claims. And 3 in 3 years, you're probably going to lose your house insurance. You have 3 claims in 3 years. So how many claims are too many? It's the same idea. 1, 2, 3. Anything in that range gets you in more danger of an increased premium or the loss of insurability, which is what the Oregon Buyer's Advisory talks about. It's so great about it. All right. So now I do have part of this survey, what the percentage of premium increase is from 1 claim. And it seems in Oregon that would be from 2 claims. Because it looks, if your first one's a freebie under the statute, it looks like your second claim would act as your first claim. So here we go. On the worksheet, 13%. What increases your premium by 13%? A fire claim. That makes sense. Fire is the big ticket item. So fire is 13%. 12% is water. Not flood insurance, and your residential offer, your residential real estate contract talks about flood insurance separately. And we know flood insurance is a separate issue, but you can still have water damage from a burst pipe, and that would be covered. So water can increase your premium by 12%. There are 2 for 6%. It is hail and wind in either order. Hail and wind are each at 6%. and then 2% is other. All right, well, that brings me to, let's turn to page 8 and talk about the gap in residential real estate.
Can I ask you one question? I don't know if you're going to get to this. If you are, so 12% water. In Oregon, as you know, it rains a lot here. So we have mold issues, which are pretty common. Where does mold fit?
It wasn't an automatic increase in premium. These are the big tickets.
Okay.
These are the insurance claims. Can you even file a claim for mold? Meaning mold gets remediated.
Hopefully.
I'm just stream of consciousnessing this, and I'm not an insurance professional, but I have seen a lot. What they would look at is what's the source of the mold. If it was water, they would look to see if you remediated quickly. If you didn't, they will reject the claim. So for example, if there's water damage, they'll walk in and they'll look to see if there's a circle in the ceiling, because spontaneous water damage does not stain the ceiling like that. Slow leaks do, and slow leaks are not covered. Slow leaks mean the homeowner didn't maintain the property, and that violates a separate provision of the insurance contract. So it would be I think they would look for the source of the mold.
Okay. Yeah, which makes sense. And someone just commented that most insurance companies exclude mold. Insurance doesn't cover the mold work, mold remediation. So another one of the exclusions, the fine print.
Right. What we just did is what I want everyone to do. What do we know? How do we extrapolate? What we just did was, here's what we do know. And then it probably is excluded, but also they would look at the source, because mold itself is not a source. And so
can we go back to a question?
Sure.
One of our attendees has asked this twice. So I just want to make sure we get it. Page 6, the 3 for 3 number of claims. 3 was three claims within 3 years. They want to know what the 3 stands for. What was?
The number of claims is 1-2-3.
Right. Okay.
That's number of claims. Duration was above it, and that was 753.
Got it.
So if you combine those two, anything within a 3-year period is your target danger box. One claim in Oregon, you get sort of a free pass, but your second claim within 3 years is not a free pass, and all this stuff will happen. And by the third claim within 3 years, it puts your insurance at risk and your personal insurability if you were the one who filed the 3 claims. Remember, you have a personal clue report. So they look to see, they don't know that your house is going to be struck by lightning. But are you likely to file a claim? And that's what they're looking at. And they can look at other factors, which are a little bit beyond what we're talking about today. But in terms of underwriting, clue reports definitely affect underwriting. All right, which brings us to page 8. And at page 8, this is where I'm looking for interaction from the group. What you're seeing, what you're thinking about, because there's a different strategy as a seller's agent than there is as the buyer's agent. Okay, there's a different strategy. So the buyer's agent, we talked about this earlier. The buyer's agent, why wouldn't your buyer want to know about clue claims? No, the buyer would want to know. We know the buyer does not have direct access, but the buyer would want to know, because if this house, and there's an actual house that this happened to, in the previous year and a half, the house had been struck by lightning 5 times. And the buyer found out because it was on the clue report. 5 times in a year and a half. It's like a lightning rod house. Would you really want to buy that house? You'd have to have the most expensive surge protectors ever for all of your electronics, besides the other damage. So the buyer would want to know, is this house a lemon? One of the things that clue reports show is maybe there's something that wasn't properly fixed that is still an issue. It will be an issue for you as the buyer. So the buyer, the only way for the buyer to get the clue report itself is to require it in the offer.
How long does it take typically to get it? Which makes sense. They'd ask for it in the offer. Offers accepted. How long once the seller requests it? Do they request it directly or through their insurance agent?
They go directly to clue, and that's coming up.
Okay.
But we can talk about it now.
Sorry to jump the gun.
No, it's fine. What's interesting about this class is everyone knows what I need to cover. And so you're asking the questions, and sometimes it's coming up, and sometimes we'll talk about it now, and I'll show you where it is in the materials. You contact clue directly. The seller has to. So the named insured has to contact clue, and they have a phone number and a form. So either method. A+, they have a website, but you have to call. It's the only way to get it. And so I don't know the exact time because I've never done it, but I don't think it's a lengthy process because it's all digitized.
Okay.
But this would be something an insurance professional may know. And if your insurance professional says, what's a clue report? Next. That's a demarcation line. We need someone who actually has some experience with clue reports. But the buyer needs the information in the clue. Here's a question. This is your homework, and I'm not checking up on any of you. But when I give you homework, it's giving you a substantive conversation to have with your insurance professionals to actually enhance your relationship with those professionals. Because let me just give you a sidebar. Have you ever been at an event where someone said, it was great talking to you with you, and they did all the talking? People love to share their professional knowledge. So if you call up your insurance professional and ask these substantive questions, they're going to think even more highly of you. You're engaging them in their expertise and letting them be the expert. People love that. So you want to do that. But one of the things is, and this is something I cannot find a citation for. It drives me crazy. I can't find a citation for it. So we can't force them to do it. But will your insurance agency tell your buyer what's on the clue report? We know they can't give it. That would violate federal fair credit laws. They can't give the clue report to your buyer. But will they tell the buyer what's on it? Now, one thing I've been thinking about is if an item on the clue report would increase the premium, I think the underwriter would disclose that to the buyer. Your premium is this, and here's why. It's higher than you were expecting, here's why. But so far, and I've been teaching across 16 states. I've never taught in Oregon. This is my first Oregon class, and it's virtual. I'm happy to see you all from Nashville. But I always ask wherever I go, and so I'd love to know the information you find out from your insurance professionals. Will they tell the buyer what they see in a clue report? Because we don't need the full clue report. The buyer just needs to know what's on it. Zero claims in the previous 5 years. Great. That would be great news. 1 claim, but it was 4 years ago. 2 claims within 3 years. What's the difference? 2 claims within 3 years is really bad.
It seems that if it would impact the amount of premium and insurability, they should tell the buyer. Otherwise, if only the seller can get the clue report, that's sort of tricky. It puts them in a tricky spot.
It does. And so this is why I want to this is why I've taught at NAR conference 2 years in a row to try and reach as many real estate agents as I can, because we can do something about this since most of you are involved in most residential real estate. But it just seems to me that it absolutely should be told to the buyer when it increases the premium. And I have some litigation. There's not a lot of litigation about clue, but what there is, because no one knows about it, right? But there is some, and one went all the way up to the Montana Supreme Court. If we have time, I can tell you that story. But it all was a miscommunication where it would have been prevented if the buyer's underwriter had just told him what they were looking at. And they didn't tell him because it didn't affect his premium. That's why they didn't tell him.
Interesting.
If I could find something to force them, but I can't. I can't find anything to allow us to force the insurance underwriter to tell us. I think they should. I think in some cases they do. And it's not a violation of federal fair credit if you just identify the listing without giving them the clue report. The whole protection is that you could steal someone's identity.
It seems that if there's something on the that has impacted the house that would be material, and it's on the clue report, and the current seller knows about it, then they have an independent duty of disclosure aside from what's in the clue report.
Right.
So the seller could find themselves in having other issues even aside from.
And I see something in the chat, which I appreciate and see a lot, is if it's low inventory and you're looking at bidding wars, you don't want to be the less attractive offer. So that would be the only reason a buyer's agent, that would be the main reason for a buyer's agent not to put it in the offer. But you would want to be working with an insurance person who will tell you anyway.
Yeah.
You don't need to see it if the insurance underwriter will tell you what's on it. Problem solved. So I just want us all to have this conversation with, and you should be recommending more than one. You should not recommend only one of any profession, because that means you pick the person. And nationally, real estate licensees have been sued for home inspections gone bad, for example, because they only gave one name. Doesn't mean you're ultimately responsible, and in your contract it says you're not responsible, but you don't, do you even want to be sued? So give multiple names, make sure they're all awesome, only awesome on our lists. We're inclusive, not exclusive. So if they're not awesome, they're just not on the list and you don't talk about them. Awesome on your list, hey, here's 3 really great choices. But
I
you
think
want to make sure that they would tell them, oh yes, please.
I was just going to say, I think part of the problem here, and I'm guessing it's a problem across the country, is that because most buyers don't ask for it, insurance agents, until their binder request comes at closing, you're not going to get any of the data until after the fact. And that's when a buyer really can get screwed. So if our agents can get in the habit of asking, because I would guess 95% of the insurance agents, until they're a binder request from the lender, usually right before closing, they're not going to have that information to make a decision until after they've already closed.
Right, so sooner. Most of what I teach, my classes would be so much shorter if people would do things either at all or sooner. And so this is a classic example. Sooner is always better for a number of reasons, particularly if there's going to be an issue, because your buyer may have insurability issues. It may not even be the house. It may be the buyer who has insurability issues, which is what the Oregon Buyer Advisory explains. So we're going to be looking at that coming up. So anybody have anything else about the buyer side before we talk? Well, I have one more thing about the buyer side. So please put it in the chat if you have it before we switch to seller, but contingencies. Now, as an outsider, I don't have a login to your website, so I have not looked at a current Oregon offer, but I did look at what I could find, and I saw your insurance provision, and it talks about if properties in a designated flood zone, the buyer acknowledges that flood insurance may be required. And then you have in your contract, the buyer is encouraged to promptly verify the availability and cost, which is the 2 important things. Can you even get insurance, and what will it cost? That will be secured, that will be secured for the property. So I saw that in this clause, it looks like 3.4. In some states, you can get around it by looking at the inspection contingency. And so I don't know how you feel about your inspection contingency. It looks like paragraph 15, and this could be an old version, is talking about what we think of as inspections, physical inspections, and not necessarily the insurance or the clue insurance claims history. But the next section, professional inspections, it's inspecting the systems anyway. So in other states, the way around it is, because it's 50% of the problem to require clue to be given to your buyer. But if your buyer wants to get out of the transaction, is there a contingency in place besides no funding? The clue would have to be fairly significant in order for the loan to not close.
Yeah, if they wanted, if they would need to write it in, a contingency for the clue, based on the clue report, and then allow a certain period of time to review. And then if a seller agrees to allow them to terminate based on the clue report without additional buffers, then.
So this is something I would like to see, is some common language for everyone to use instead of reinventing this wheel.
Mhm.
And most of these forms were written by lawyers and approved by your state and your state association of realtors and all of that. So it's something to think about. I wouldn't start writing clauses without having it checked by a lawyer, because you want to make sure you don't want to half do it,
Yeah.
where they can't get out, but you wrote, because it's still a binding contract. It just doesn't get them out of the offer. So that's the contingency on our worksheet on page 8. Then at the bottom, the seller. So let's talk about being the seller's agent. If the seller has a claim 8 years or older, no problem. Get the clue report because it's clean. If the seller has a claim 6 years, it won't show up on that seller's disclosure you get from Clue. So again, get the clue report. It actually enhances your listing, takes all the guesswork out. Look, there are no clue claims on this house for the 5 years that are affected by the Oregon statute. So in Oregon, if you have claims that are 6 years or older, the seller should think about getting the clue. And if there's anything on the clue that shouldn't be there, you get to get it removed. Clear up the clue report, which will help you and will help your buyer as the new owner. So that's one straightforward way. And when you're approaching for sale by owner, you know how long they've owned the house. And so you would know whether you could use that angle. You were asking them about clue. And then the impact on the sale. Now, this is the piece that I get the most pushback. We, as a national, across the country in every state, real estate agents in every state, we don't need to pull the clue because it's never affected one of my transactions. Right, you can close, but it doesn't mean it's not going to affect your buyer who's the new owner of a house that had some deficiencies no one told them about. Or that may be one claim away. So let's say there's already a claim and they file a claim and it's within that 3-year period, that's not looking good. And one more claim, they're thinking the house is on its second claim, it's really on its third claim. So that's what I worry about, the unknown, that the new buyer has no idea how many claims are within that dangerous 3-year period.
Mm-hmm.
And so it may not affect your closing. And this is something Jenny and I were talking about before we started. It may not affect your closing, but did you know that the insurance binder is temporary? So go ahead and write in the chat if you knew that the insurance binder was only temporary, because many insurance underwriters give themselves, after closing, anywhere from 30 days to 90 days to fully investigate things like the clue report. So I have an actual example. This occurred in Ohio. Let me just hold on one second. I have to take a sip. This occurred in Ohio. It was actually a realtor. So licensed real estate professional bought a house. 1 month into his ownership, his big brand insurance company returned 11 months of premium. Why would a big brand insurance company return 11 months of premium? They had pulled the clue report. They found 3 things. The seller had received insurance claims money on the roof and didn't repair the roof. Same thing for the front steps. And third, too many claims on this house. And he was writing, this terrible insurance company. And I wrote back, nicer than I'm saying it now, this is insurance underwriting 101. They weren't good or bad. This is what they do. This is their actuarial tables. You now are more likely to file a claim, which means you've increased the houses and increased risk they didn't know about, and they don't want to insure it. So that's the danger. Do you want your client 30 days after closing to lose their insurance and end up in the forced place insurance, which, as we talked about, costs more and covers less? So those are some of the important things to be thinking about as the buyer's agent, but also as the seller's agent. Now, we had the clean pass is no claims at all. No claims, all claims are 5 years or older. Those would be reasons for the seller's agent to encourage getting the clue report.
Do you see that last question there?
Yes, I just saw that pop up. So yes, well, this is the answer to this question is your homework, and I would love to know the answer, so clue me in too. I want you to ask your insurance folks, what can you tell my buyer about what your underwriter is seeing on the clue for the subject property? So the subject property, buyer is applying for insurance because she can't get the mortgage if she doesn't have insurance. What can you tell us? Will you tell us the number of claims? Will you tell us the type of claim? We know from that Washington, D.C. area example, they were told it was $9,000 in roof damage from a tree. I mean, they knew the whole deal.
So it seems just listening to you that offer written, no contingency in the deal, seller hasn't agreed to it. If a buyer simply calls their insurance agent that they intend to move forward with insurance with, I'm guessing that agent would say, I can't get the clue report. What authority do I have to get the clue report on a house you want to buy? It's not my insured. I need permission and authority to do so.
It would be part of the underwriting process. So when are you underwritten as the buyer?
Right. Well, once the deal comes together, if it's not in a contingency, I get it. They got to do it. But I'm saying if they're doing their homework beforehand as part, then okay.
There's no way to know.
Yeah.
And that's just how it goes. So that's why I would like to see language for everyone to use, because if we don't write the contingency properly, it's not a contingency. So we can do 50%, must deliver a clue report, a recent clue report. And that would be that 5-year report. It's called the home seller's disclosure report. It's a particular report. It redacts their social security number, their date of birth, their name. It's just about the subject property. You can't steal their identity for credit purposes. It's appropriately redacted. And that redacted is just, have you ever seen the federal government declassify documents and there's all those black bars all over? That's redacting. So that's what they'll do on this. but that's 5 years and the seller. So that's why it would be so great if sellers agents, at least on the houses where it's clear, would start to use it as a sales tool, as a listing feature. Hey, we have a clear clue report.
Yeah.
So we know, and I know some sellers agents, I know many of you are asking your sellers, hey, please get a home inspection. This is another thing I've been working on for a long time, helping sellers agents get the seller to invest in that home inspection. That also affects divorce real estate. And so it's really important. And you know, sometimes they think, oh, if I don't find it, no one will. And we know the buyer's home inspector does. But it would be really great if we could start to use clue reports in an advantageous way on a listing, which would make your listing look even better. I mean, if people already know, wow, it's going to be much easier to get insurance on this house because there's a clear clue report.
Yeah. It's such an important supplemental piece of information from what you get in a home inspection, because as we all know, home inspectors know a lot or a little about a lot, a little about a lot. So they can easily miss something that's on the clue report that is an important factor.
And they would inspect differently. It's not fair to say, hey, do you think this house has ever been struck by lightning? If they paint over the scorch marks, you wouldn't know, right? You know, the flames that came out of one of the electrical sockets, if you just fix that, they wouldn't know. So it's not fair to require that of home inspectors. Now, right as we're wrapping up, page 9 is where I show you what's in your Oregon Property Seller Advisory and your Oregon Property Buyer Advisory. And what's so awesome about both of those is, for example, in the seller advisory, insurance claims history for a home may affect the cost of insurance or even its insurability, so cost and availability. Most insurance companies use Clue. Sellers have made claims, may want to check their Clue report prior to marketing to make sure there's no difficulties. That's exactly the issue. And this is why I've been a fan from afar of this document, because it has done what most other states do not do. And then the buyer advisory is pointing out the buyer's claims history and credit report may also be used to determine your insurability as the buyer. Insurers have used Clue reports and other information to cancel coverage after closing, which is just what we were talking about. It's in your guide, which is why my hope is Oregon will lead the charge on this, because you already have been very awesome about it. And let's just kick it up a notch.
With that kind of compliment, looks like we're going to have to.
Well, you're the most awesome. So of course, you know, we could get this going in a way that doesn't make anyone uncomfortable with your negotiation features. I mean, if we just take smaller steps, maybe we can get to the place where they're used more regularly. And so I've also given you links to the Oregon Insurance Information Council. The Washington Insurance Commissioner has a summary about Clue, and some of you may be dual licensed. And then the Clue electronic request form, that's the portal link. So it's on page 9. How to help your sellers get that free Clue report is on page 9. And then finally, as we wrap up, I just want to give you my question. So if you're on a for sale by owner pitch call, this one question can show them that for sale by owner website isn't going to cut it. You're going to give them information about something they weren't told about, and it shows them why, just one of the many reasons why they need a realtor. So here's the question. Are you ready? What about the Clue report? That's the question. I want everybody to write that down. But if you're on a call or a listing presentation itself and ask them, what about the Clue report? What do we know from those surveys I showed you, 2016 and 2014? America is clueless about Clue. We know this. So for the most part, they're going to say, what? When I first learned about Clue, it was an agent in the 3rd class I ever taught on divorce real estate. This was in 2008. She raised her hand and said, what about the Clue report? And I did not have a clue what a Clue report was. And so she told me sometimes people get the insurance money for the roof, the big ticket item, and they go on a cruise and buy a car instead of repairing the roof. That causes other problems for them as a seller, and it causes problems for the buyer. So when you say to them, what about the Clue report, and they don't know what it is, you explain it's a free document that will make your listing even more attractive if you have no claims. And if there may be errors, we could get those fixed, but those claims will affect the underwriting of your house for any buyer. What did we just do in those 3 steps? You sound much more informed than anyone else they've talked to. Their for sale by owner website didn't give them any of that information, because remember, America is clueless about Clue. And of course, they're going to be thinking, what else do you know that I need?
Yeah.
That foot in the door. So my scripts are always short, but what about the clue report? Now I'll just give you one example. My last live class was January in California. And when I teach divorce real estate, I teach 2 days live. And so the night between, one of the agents in that class went to meet with one of her sellers and came back the next day and said, I had talked to him about the clue report, and he said in response, that's why I love working with you. You know your stuff. This is a listing she already had. And he was even happier that he was working with her.
It's all
So
about
that's
value. It's all about
Right.
showing value. And
It's a
quite
value
frankly,
proposition.
if a buyer requests the seller to provide the clue report and the seller says no, that is a red flag that you might think about and take into consideration on whether you want to stay in the transaction. What's the seller hiding? And I'm guessing since most people are clueless, they have no idea if there's anything on there. But then
But
again,
not from, well, how long have they owned the house? If they own the house for 12 years, they're the clue. And in California requires the seller to disclose what they know. Well, if they've only owned the house for 2 years and have filed no claims, they can't tell you anything.
yeah.
So that doesn't tell you there isn't something, but I agree. If the seller says, oh no, it means they filed a claim and they don't want you to know about it.
Yeah.
And maybe they bought a car with the roof money and you need a home inspection to make sure that roof's okay. Now your home inspector would probably tell you to get a roofer to come check it, but it would be so much easier to give this information to your home inspector from the get-go. You're protecting your buyer.
Yeah. Yeah. Well, thank you, Professor Murray. This was really, really useful. And we will continue to advocate. As you can see, we already do on our buyer advisory and seller advisory on the use of clue. I think it might be something to consider for the forms committee to add some contingency language in there, whether it's a checkbox or not, if the buyer wants it, but at least make it an option.
Right. It would just, that way no one is going out on a limb trying to figure out what this language should be.
Yeah.
That would actually trigger the ability to rescind the offer. That's what I'm worried about. We can all require the clue, but can we get out of the offer based on what's on the clue?
Precisely. Well,
Thank you so much.
any parting words, or we'll see you next time for another class on from Divorce This House.
Well, yes, thank you so much, Oregon. This is my first official Oregon class, and I'm delighted to Zoom with you. And since we may have more time for Zooming, my spring semester just ended, so we will hopefully be.
Excellent.
Get some additional topics going.
We definitely look forward to having you back. Thank you very much, and welcome to Oregon.
Thank you so much.
Kind words. Take care, Professor. Thank you.
Bye, everybody.